After you have been sworn in, your hiring attorney will start with questions designed to show your qualifications to be the expert and to present opinion testimony. This is the voir dire phase. The term voir dire comes from the French and roughly means to speak the truth. In the United States, voir dire applies twice during a trial. The first time occurs during juror selection. Prospective jurors are questioned about their backgrounds and any potential biases they may have to determine which of them will be chosen for the jury. Voir dire also occurs when expert witnesses are questioned about their backgrounds and qualifications to determine their admissibility for offering expert opinions. You will first answer the easy questions from your retaining attorney about your name, your current and past employment, and your education. You will also answer questions about any additional training that you received in your specialty, about any memberships you may hold in any professional organizations, and any special credentials or certifications that you may have. The opposing attorney may ask questions in this phase in an attempt to clarify parts of your background and expertise. He may attempt immediately to discredit or disqualify you, or simply lay a legal foundation for questions to be asked later. The second main phase of trial testimony is called direct examination. In this phase, you will be asked questions, familiar usually, by your retaining attorney about your opinions and your investigations. His series of questions will enable you to recount how and when you joined the case, what work you performed, what factual findings were determined as a result of your analyses and efforts, and what your expert opinions are about all of those findings. He will ask you to explain to the court the foundations for those opinions, largely drawing on your specific methodologies, any known industry standards or guidelines, and any peer reviews that were performed on your work. The rest of this lesson focuses on what you need to consider during your direct examination. The third phase of trial testimony is called cross-examination. In this phase, the opposing attorney has the opportunity to ask you questions about any of the facts in evidence that you have reviewed, and about any of your responses to questions during direct examination. Lesson 12 concentrates on the dangers of this phase and what you need to know to survive it, and better still, to walk away with your opinions, your reputation, and your integrity still intact. Cross-examination can be damaging, demeaning, and frustrating. The cross-examining attorney may attempt, 1, to discredit you personally for your conduct or for your limited experience and knowledge in the specific subjects covered by the trial. The cross-examining attorney may also try to discredit you professionally for your choice of tests, for the scope of your analyses, for the extent of your investigation. His questions usually will try to make it seem as if you didn't do enough, or you didn't do it right, or you didn't even do the right things. He'll also try to discredit your final opinions in a host of other ways. He may try to convince the jury that your conclusions do not logically or completely or even accurately follow from the set of facts that you considered. He may try to confuse you in his questioning to make you seem less knowledgeable or competent than you are. He may point out errors in your data or propose other conclusions that should have or could have been drawn. A fourth phase in the trial may occur. Redirect examination occurs after the opposing attorney has cross-examined you. If your retaining attorney feels that the cross-examination damaged you but in a repairable way, or misled the jury about your testimony, he can ask a series of additional questions. Your attorney at this point may only ask questions about subjects that were broached by the opposing attorney during the preceding cross-examination phase. Both his intention and yours will be to minimize the importance of any points made by the cross-examining attorney and to give you a final opportunity to restate your main opinion. This will generally be short, if it even occurs at all. You should act and answer as confidently as you did earlier in the trial. To be complete, yet another phase may still occur. If your attorney has asked any questions in the redirect phase, then the cross-examining attorney will be able to come back to ask additional questions. This final phase is called recross examination. Each of these phases is shorter because the rules limit the attorneys to questions only on subjects broached in the preceding phase. During recross examination, the opposing attorney can only ask questions about what your attorney brought up during redirect. Nevertheless, you need to maintain your alertness just as you did throughout the cross-examination phase.